Imagine this for a moment. A top Trump immigration official, the commander of a major federal operation, sitting in a courtroom and hearing a federal judge flat out say that he admitted to lying under oath. Not just bending the truth. Not just shading the facts. Actually lying, and getting caught doing it. You don't see that every day. And if you think judges are just rubber-stamping the government's story, this case out of Chicago might make you think again. Because what happened inside that courtroom is more than a local scandal. It's a moment that could change how the justice system treats federal agencies that have, for decades, been given the benefit of the doubt. Welcome back to the channel, everyone. If you've been following what's going on in immigration enforcement and government accountability, this one's going to hit you like a lightning bolt. Today we are talking about the extraordinary federal court hearing in Chicago, where Judge Sarah Ellis confronted Trump's immigration commander, Greg Bovino, about his conduct during the operation known as Operation Midway Blitz. And in court, on the record, the judge said that Bovino admitted to lying during his deposition. Think about that. A federal official under oath, testifying in a major civil rights case, admitting to false statements, and the judge making sure it's part of the record. So let's unpack this, piece by piece, because the implications go far beyond Chicago. This isn't just a case about one official court being dishonest. It's about whether the courts are finally starting to push back against decades of automatic trust, what lawyers call the presumption of regularity, that the federal government always acts in good faith. Are we seeing the end of that era? Here's what went down. The case started with a lawsuit brought by a coalition of journalists, clergy, and protesters. They said that during Operation Midway Blitz, that's the Trump administration's high-intensity immigration crackdown in Chicago, federal agents trampled on their constitutional rights. There were reports of excessive force, tear gas used against peaceful demonstrators, even clergy who were pepperballed while praying. The images and video went viral in Chicago last summer. You might have seen them online, agents in black gear, tear gas clouds filling the streets, people coughing and covering their eyes, reporters shouting that they were being pushed back even while clearly identifying themselves as press. The plaintiffs argued that the operation wasn't about public safety at all. They said it was about intimidation, silencing dissent, sending a message. And the judge, Sarah Ellis, agreed that the evidence was serious enough to hold hearings and possibly issue an injunction. Now, if you're not familiar with how that works, a preliminary injunction is like a judicial stop sign, a signal that what the government is doing might be unlawful, and that harm will continue unless the court steps in. For a federal judge to consider one against the U.S. government is already a big deal. But what happened next made it historic. As part of the hearing, the defense, that's the federal government, submitted depositions and video evidence from Commander Greg Bovino, who was leading the operation in Chicago. During questioning, Bovino was asked about specific incidents caught on camera. And this is where things started to unravel for him. One video showed Bovino himself tackling an older man to the ground. It wasn't a quick scuffle or a mistake, you could clearly see him lunging forward, taking the man down. When he was asked under oath about the clip, Bovino denied it. He said, "No, that didn't happen." The attorney questioning him looked stunned, reportedly asking him, "So if someone's watching a video that shows you tackling a man, you'd tell them not to believe their eyes?" And according to reports from inside the courtroom, Bovino doubled down at first, until later, when he had to admit that yes, that video was real. Yes, he had lied. Then came another deposition passage, this time about a Protestant clergyman, who had been hit with a pepper ball fired by one of the agents. The man was praying, not engaging in violence. The footage went viral for weeks. When asked if he had witnessed the event, Bovino claimed he hadn't seen it. But again, Judge Ellis said in court that this too was a lie, that evidence showed he was right there, and he knew what happened. You can imagine the tension in that courtroom when the judge laid it out, not just mistakes, not misremembered details, but deliberate falsehoods. And then came the tear gas story, maybe the most infamous moment of all. There's a well-known photograph of Bovino tossing a tear gas canister into a crowd of protesters. When asked why he did it, he said he had to, because he'd been hit by a rock thrown by one of the demonstrators. That's the official justification that was filed in reports and statements to the court. But when the evidence came in, when the judge saw the footage and reviewed the testimony, it became clear that no such rock was ever thrown. The thrown rock story, as the judge put it, was fabricated. During the hearing, Judge Ellis said plainly that Bovino admitted that wasn't true. Her exact words were quoted by reporters. He admitted that he lied. You could feel the air go out of the room. That is not something federal judges say lightly, especially not about a senior official representing the U.S. government. And the fallout from that admission was immediate. Judge Ellis issued a preliminary injunction, a sweeping order restricting what Bovino and the agents under his command could do during Operation Midway Blitz. It said that federal officers were barred from using tear gas, pepper balls, or other so-called less lethal weapons against protesters, journalists, or clergy unless there was an immediate threat of serious injury or death. It also said agents had to give 2 clear, audible warnings before deploying any force, and that they had to wear visible identification and activate their body cameras during all enforcement actions. She even initially ordered Bovino to check in with her court every day to report on compliance, though an appeals court later said that was excessive. They called it inquisitorial. But Judge Ellis made her point. She was, as one observer put it, putting him on a very short leash. Think about that, a federal judge basically saying, I don't trust you to follow the law, so I'm going to watch you myself. That is a remarkable break from tradition. Normally, courts assume the government's word is reliable. There's even a legal term for it, the presumption of regularity. It means courts typically defer to the government's good faith. If a federal officer says something happened, the court tends to accept it unless there's clear evidence to the contrary. That presumption has been baked into American administrative law for decades. But this judge said, essentially, not this time. Not when the evidence shows you've been lying. So here's where this gets even bigger. The question that's now being debated among lawyers, journalists, and even some federal officials is whether this case signals a broader shift, whether courts across the country are starting to say enough is enough when it comes to federal dishonesty or misconduct. Because it's not just this one case. We've seen similar issues crop up elsewhere. Remember the Kilmar-Brigo Garcia case? Or the so-called sandwich thrower case that made headlines the same week, where a jury threw out charges against an immigrant accused of assaulting an agent because the testimony didn't hold up. It's a pattern. Over and over, the government's story is being questioned, and sometimes dismantled. And that raises a question for all of us. What happens when the public, and the judiciary, stop believing the government by default? For decades, federal law enforcement has counted on credibility as its greatest asset. Once that's gone, once a judge actually says on the record that a top official lied under oath, it changes everything. It erodes the automatic trust that courts have long given agencies like DHS, ICE, or CBP. Now, viewers might be wondering, can someone like Bovino actually face consequences for lying under oath? In a normal era, yes. A federal official who knowingly lies in a sworn deposition could be charged with perjury or making false statements, both serious federal crimes. Under 18 U.S.C. Section 1621, perjury carries up to 5 years in prison. And there's also 18 U.S.C. Section 1001, which covers false statements to federal investigators or in official proceedings. Those laws exist precisely to preserve integrity in the system. Because if officials can lie without consequences, the rule of law collapses. So why didn't the judge hold him in contempt right there? That's what many observers asked. Contempt of court is a powerful tool. Judges use it to enforce honesty and order in their proceedings. But it's also discretionary. Maybe Judge Ellis decided to focus on the injunction first, to lock in the protections for journalists and protesters, and leave criminal consequences to another day. Maybe she's building a record, piece by piece, knowing that this case will go to the 7th Circuit Court of Appeals. Maybe she wanted to make sure every lie was documented before the appellate judges review it. In fact, some legal experts think that's exactly what she's doing, creating a clear record showing that the government's witness, under oath, admitted to dishonesty, so that when the higher court reviews it, they won't dare disturb her findings. And remember, statutes of limitations on perjury or false statements are generally 5 years. So even if this administration stays in place for a while, that legal exposure doesn't just disappear. Future administrations, or independent prosecutors, could still bring charges down the line if they find evidence of knowing, intentional falsehoods. In other words, the clock's ticking, and just because it didn't happen today doesn't mean it won't happen tomorrow. There's also the question of motive. Why lie? Why would someone in Bovino's position, a seasoned officer, leading a major operation, fully aware that he's under oath, take that risk? It speaks to a mindset of impunity, doesn't it? A belief that there will be no accountability, that truth is flexible when you work for the federal government, especially under an administration that prizes loyalty over integrity. That's not speculation, that's been documented repeatedly in cases across the country. This wasn't a one-off mistake, it was part of a larger pattern, where officials felt empowered to say whatever served their narrative. And that's what Judge Ellis was pushing back against. When she said he admitted to lying, she wasn't just calling out one man. She was sending a message, that in her courtroom, facts still matter. Evidence still matters. You can't just gaslight a court of law and expect to get away with it. It's a line in the sand, the kind of line that has been missing for too long. Now, this brings us to an even deeper question, one that affects not just Chicago, or this specific case, but how we as a nation think about law enforcement and truth. For decades, people have talked about the presumption of regularity. It's an idea that sounds harmless, even logical, that government officials, acting in their official capacity, are presumed to do their jobs correctly and honestly. Courts rely on it because they can't possibly verify every single claim the government makes. But what happens when that presumption becomes a shield for misconduct? What happens when the default trust given to authority becomes a license to lie? If you've been watching the pattern, from Chicago to Portland to Washington, D.C., you can see that shield cracking. The judiciary is no longer looking at federal agencies as automatically credible. Instead, judges are asking for evidence, demanding transparency, and in cases like this one, calling out deception for what it is. That's a fundamental shift, and it's one that could define the legal landscape for years to come. It's worth pausing here and thinking about how rare this is. Federal judges almost never accuse high-ranking officials of lying, at least not in open court. They might find testimony not credible or inconsistent with the record, but to say admitted that he lied. That's nuclear language in judicial terms. It puts a permanent mark on that official's record and sends shockwaves through the agencies they represent. Inside DHS and ICE, you can bet there were emergency meetings after that hearing. Because if one commander gets caught lying, it raises questions about everyone's reports, everyone's depositions, every case built on their word. And yet, even with all this, Bovino still holds his post for now. That's the part that stuns people. In a normal administration, a revelation like this, an admission of perjury from a top officer, would mean suspension, investigation, probably resignation. But not here. So far, there's been silence from the top. And that silence sends its own message, that the system protects its own, at least until someone forces accountability from the outside. Maybe that's why Judge Ellis is so important in this story. She's one of the few people in a position of power actually saying, no. Enough. This isn't how justice works. It also says a lot about how fragile institutional trust has become. Think about it, when a federal judge says, he admitted that he lied, she's talking not just to the lawyers in front of her, but to the public watching outside. She's acknowledging what millions of people have suspected, that some parts of the federal machinery have been running on deception, and that only sunlight can fix it. For those who have felt unheard or gaslighted by official narratives, moments like this are vindicating. But they are also terrifying, because they show just how deep the rot goes. And here's where things get even more interesting. The legal community has been buzzing about how Judge Ellis structured her injunction. She didn't just limit the use of force, she wrote in detailed oversight mechanisms, like mandatory identification, camera use, and even daily compliance check-ins at one point. Those are the kind of measures you usually see imposed on rogue police departments after years of misconduct, not on federal agents mid-operation. She was clearly trying to set a standard, and to show the appellate court, if and when this case goes up, that she did everything possible to ensure constitutional compliance without overstepping. If the Seventh Circuit does review it, they'll be looking at a clean record, a record that includes, in the judge's own words, the fact that a federal commander lied under oath. That phrase, lied under oath, will echo for a long time. It's the kind of statement that follows someone for the rest of their career. And it could have ripple effects beyond Bovino himself. Already, lawyers representing other plaintiffs in civil rights cases are citing the Chicago case as evidence that federal officers can't automatically be trusted. It strengthens the argument for judicial oversight nationwide. And it's a wake-up call for Congress, too. If lawmakers want to preserve public confidence in law enforcement, they need to show that no one is above accountability, not even the people who claim to be enforcing accountability on others. So where does this all go next? The Justice Department has said it will appeal. That means the case will head to the Seventh Circuit, where a panel of judges will decide whether Judge Ellis's injunction stands or gets rolled back. They'll look at the evidence, the testimony, and the legal standards for use of force. But they'll also have to grapple with the elephant in the room, the fact that a federal judge, after reviewing sworn testimony, said the government's own commander admitted to lying. That's not a factual dispute you can easily brush aside. If the appeals court upholds Ellis's ruling, it could set a powerful precedent, one that reinforces judicial scrutiny of federal law enforcement and strengthens the rights of journalists, clergy, and protesters during federal operations. If they overturn it, well, that will raise serious questions about whether the judiciary is willing to look the other way when the government lies. Either way, this case is going to make waves. For now, the injunction is in place. The operation in Chicago is still technically ongoing, but it's under heavy legal constraints. Agents must document every use of force, justify every deployment, and show that their actions comply with constitutional standards. That's not how federal crackdowns usually work, but maybe that's the point. Maybe this is what it looks like when accountability finally catches up. Before we close, think about the bigger picture. This isn't just about one commander or one city. It's about a cultural shift in how the judiciary sees the executive branch. For decades, judges assumed that when federal officials swore an oath, they meant it. That when they filed reports or testified, they were telling the truth. That assumption, that presumption of regularity, is one of the quiet pillars of our democracy. Without it, the whole system starts to wobble. But when it's abused, as it has been here, it becomes a shield for wrongdoing. So maybe this case isn't a sign of decay. Maybe it's the first step toward rebuilding trust, the kind that's based not on blind faith, but on verified truth. Because here's the thing, lying under oath isn't just a personal failure. It's an institutional betrayal. It tells every citizen that the rules don't apply equally. That if you have the right badge or title, you can twist the facts to fit your agenda. And that's the one thing democracy can't survive, a two-tier system of truth. So when a federal judge stands up and says, he admitted that he lied, she's doing more than exposing one official's deceit. She's defending the principle that even the government must answer to the truth. Now, what happens next is up to the legal system, the media, and the public. Will there be criminal referrals? Will the appeals court uphold the injunction? Will other judges follow Ellis's lead? These are the cliffhanger we are watching. And they are not just procedural details, they are tests of whether our system still has the courage to hold itself accountable. So here's the question I want to leave you with. When the next government official gets caught lying under oath, will the system act, or will it flinch? Because this case could be the beginning of a reckoning. Or it could be just another headline that fades away. And that choice, ultimately, belongs to us, to how much we demand truth, how much we demand accountability, and how much we refuse to settle for anything less. Thanks for sticking through this deep dive. If you found this video helpful, make sure you hit that like button. It really helps more people see stories the mainstream often brushes past. Subscribe if you haven't already, because we'll be following this case and others like it as they unfold in the courts. And in the comments, tell me what you think. Do you believe the courts are finally losing patience with federal agencies that lie? Should Greg Bovino face criminal consequences for perjury? And more importantly, what does this mean for the rule of law in America? Drop your thoughts below, and as always, stay curious, stay critical, and I'll see you next time.